In this video, I'm going to go over some documents that have recently been released and just give you my thoughts on them. I'm going to go over probably some things that I want to debunk and hopefully provide some information and have a few hidden gems in there for you. All right, so what we're actually looking at here is the crime scene, but this is from a different day. This is not from the day of the murders. See, you could see here the F tree, and let's zoom in a little bit on the ground. Now you could see what the defense is calling twigs, but they're actually shoots from the trees. So this is what the defense is saying, were twigs that were placed on Abby's head. However, these twigs or shoots were already there before the girls got there, before February 13th. They're out there all the time. So let's make it stand out a little bit. So I'm talking about all these yellow looking shoots here. You could call them twigs, but they're really thin. They're actually shoots. So then imagine just laying down on any of these in any spot here in this area. No matter where you go, it's going to look like you have horns or antlers. So you could say, oh, look, there's horns, or here's antlers. Look, there's a horn here. There's a horn there. This is exactly how the crime scene photo is, where the victim is on the ground. They're laying on top of these chutes, and it's the defense claiming that horns were placed on there. It's ridiculous. No one placed them there. They were already there. This is exactly how the crime scene photo looks. Look, there's a horn there or an antler there. So there's absolutely no horns or antlers placed on any of the girls' heads. They're just shoots out there. They were out there before the girls got there. They're probably out there now. And that's the truth. I just remember Rick Allen's defense saying that they want to be transparent. They have nothing to hide.
What the judge takes away from your argument today?
We have nothing to hide, and, you know, transparency is important in government. It may be weird for defense lawyers, I suppose, to be arguing that we want things unsealed, but that's how confident we are in our client. That's how confident we are that the evidence contained in at least what's written in the probable cause affidavit is nothing for us to worry about.
So I kind of made some notes of some things that they are trying to hide, which contradicts their earlier statement. So first, they want to hide Rick's CVS records. So he used to work at CVS, and they want to hide those because something to do with his alibi. Obviously, they were hoping he was working that day, but nope, he was off during the day of the murders. The next thing they want to hide is his mental health record. I'm guessing it's because the records will actually prove he doesn't have all the mental issues that they're claiming, and maybe that he confessed to some of the mental health workers. Speaking of the confessions, Rick's defense also wants to hide the 30-plus confessions that were made, specifically the confessions that were made to Rick's wife, his mom, the medical staff, mental health professionals, the Indiana State police officers, and the warden.
Turning now to I-Team 8, the prosecutors in the Delphi murders case is fighting the defense team over whether or not the future jury will be told about Richard Allen's confession to the murders of Abby Williams and Libby German. I-Team 8's Cody Fisher is combing through those new court filings tonight. Cody.
The biggest piece of new information we're learning from this filing is the sheer number of people Richard Allen has confessed to while being held in jail awaiting trial. Now, according to the prosecution, he's confessed to 16 guards, 8 inmates, a warden, Indiana State police officers, and mental health professionals.
The defense also wants to throw out the October 26th interrogation. This is the day that they actually arrested Rick Allen. So I wonder what Rick says in that interview or that interrogation where the defense needs to hide it. And we know they also want to hide the fruits of the October 13th, 2022 search warrant that was conducted at his house, where they took his vehicles as well.
Now, shortly after that interview resurfaced, investigators interviewed both Allen and his wife. Following that interview, they applied for a search warrant for Allen's home. Now, this is one of these new documents that we got today, that search warrant. And according to that, they seized a handgun and several bullet cartridges. You may remember investigators claimed that a bullet found between the girls' bodies had been cycled through Richard Allen's gun. Also in that warrant, they seized 13 different knives along with shoes, several pieces of clothing, numerous electronic devices, as well as a piece of carpet that was cut from his car.
One other thing I realized that they want to hide is what Professor Turco from Purdue University said about the crime scene.
A few weeks ago, we told you how court documents claim the crime scene where the girls' bodies were found had pagan symbols formed with sticks.
The defense now says there's a taped statement from Jeffrey Turco, a Purdue professor, who said after seeing the pattern of sticks at the crime scene, it was, quote, given someone was trying to replicate some German symbols. It goes on to say Turco allegedly consulted with a colleague from Harvard who agreed with him. You may remember, though, prosecutors called the defense's statements colorful, dramatic, and highly unprofessional.
But I'll tell you, Turco, in his introductory statement in his report, says, it is not self-evident that these markings are runic inscriptions, nor is it immediately clear what they would mean if they were. The translation, Turco doesn't think the crime scene reflected Odinist Nordic runes by white racists who are racist against other white people who committed the first ever Odinist human sacrifice ever in the history of mankind. He doesn't think that. But the defense wants you to believe that that's what he thinks. And one last thing that the defense wants to hide from you is Libby German's cell phone data and the contents that come from her cell phone, which is likely the bridge guy video and any metadata tied to that video. In my video, Figment of Your Imagination, I went over 8 common defense strategies that we continue to see used by Rick Allen's defense. Here's what they are so you can identify them as we go over the case documents. Let's go. 1, challenge the confessions. 2, examine witness credibility. 3, question forensic evidence. 4, create reasonable doubt. 5, provide an alternate suspect theory. 6, claim mitigating circumstances. 7, make sure you could find some procedural mistakes by law enforcement. And 8, have effective storytelling. So it seems like they have been carrying out their strategy this entire time, and they will keep doing these things. So that's why I want you to be aware of them, keep track, see how the defense uses these from now until the trial's over. Okay, so let's go over some documents. This document is called Memorandum of Law in support of Defendant Allen's motion to suppress. In this document, the defense wants all of Rick's confessions thrown out because of the 30 plus times that Rick has confessed to being the one who murdered Libby and Abby. Some of those confessions were to other inmates, and Rick was likely coached by his defensive team to make some confessions where he describes the crimes and crime scene incorrectly in order to combat the times that he did describe the crime scene correctly. I'm just speculating that the defense team coached him to mix in some other confessions that are inaccurate. That way they could do a motion like this, or they could get all confessions thrown out. But I don't think it's going to work.
Allen's attorneys say they want any statements made by Allen while he's been in prison. Well, they say that those statements were not made voluntarily and came while Allen was mentally ill. And they say for those reasons, allowing a jury to hear those confessions would violate his constitutional rights. Allen has been kept at a maximum security state prison for nearly 18 months since his arrest. And in a new court filing, his attorneys say Allen has been accused of making incriminating statements to both inmates and guards while he was at the Wabash Correctional Facility between March and June of last year. They claim prison officials posted inmates at Allen's cell door and required the inmates to keep logs of all of his actions and statements and behaviors. And they say some of those inmates actively asked Allen questions. The defense team says that essentially amounts to a sustained form of interrogation, one that lasted more than 5 months, and they argue it's a violation of Allen's constitutional rights because he did not have an attorney present when he made any incriminating statements. They also say while in prison, Allen suffered from a mental health disorder made worse by being placed in isolation. They argue Allen slipped into a state of psychosis, including delusional and paranoid and highly dysfunctional behavior. So the defense team claims Allen's statements and alleged confessions were not given voluntarily, but instead as a result of him being overcome by living in an isolation cell while on suicide watch. And they say any confessions were therefore coerced and not admissible at trial. Now, that trial is set to begin in 1 month. The state is expected to use Allen's jailhouse statements against him. The defense team says the things Allen allegedly said don't match up with evidence from the crime scene and therefore show the confessions can't be true. They're asking the judge to suppress the statements altogether. In the newsroom, I'm Bob Siegel, 13 News.
And the state argues that all of the confessions should be looked at on an individual basis. And these ones in particular should be allowed in court. The confessions from his wife, which is on a recorded phone call, from his mother, the ones from the Indiana Department of Corrections staff, Specifically, this includes staff members who interact with inmates as part of their duties, mental health personnel, medical staff, Indiana State police officers, and the warden. And Rick also confessed to several other individuals from various law enforcement and correctional backgrounds. The state requests that the defense be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describe the conduct they believe to be either physically or psychologically coercive before the state is required to respond for further analysis by the court. Then he closes out by saying, in the absence of specific allegations by the defendant as to each statement against his interest that is involuntary as a result of law enforcement interrogation, the state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. So Nick McClelland wants the court to deny the defendant's motion to suppress the statements filed on April 11th, 2024. I just don't understand how Rick was mentally ill for his 30-something confessions, but somehow he was well enough to write a letter stating his support for Baldwin and Rosie, that he wanted them to remain his lawyers back when they withdrew from the case. I just didn't know mental health was like a switch that you could turn off and on as you please. So the defense put out this motion on April 15th, 2024, the motion to suppress the accused's second statement. This is where the defense wants to get Rick's second interrogation thrown out, the one from October 26th, 2022. This is the day that he was arrested. And the defense claims that Rick's rights were violated as his Miranda rights were not read to him, despite the fact that it's not law to read someone their Miranda rights before an interrogation, as long as they're not detained or being put under arrest. But we'll get into that in more detail later, which leads us into the state's response to this document, which was made available April 23rd, 2024. It's called the state's objection to defendant's motion to suppress statements. And this document essentially states that Rick Allen was not under formal arrest at the time he made certain statements, and thus the state argues Miranda rights were not required to be read. Next document we're going to go over is Motion to Compel and Request for Sanctions from April 23rd, 2024, and this was filed by Rick Allen's defense team. They submitted a request for sanctions, basically requesting the court to compel the prosecution to disclose withheld evidence and to impose sanctions for alleged discovery violations and late disclosures by the prosecution. And what this document is, it's basically a straw man argument because the state and the defense had until November 1st, 2023 to turn over all discovery. And of course, if any new evidence came in, such as an analysis or test results that came back, then they could turn that in as well. But regardless, they both had until November 1st, 2023. However, the state has stated that they have turned over all discovery, and also the state even mentioned that the defense has failed to turn over a single shred of evidence over to the state. So you'll see claims throughout this document that is asking why Nick McClelland didn't turn things over sooner, and I do have a personal favorite that we'll go over. And actually, the first order for discovery evidence having a deadline was that they had all the way up until 30 days before the trial started. So that was the first ruling, and that was from Judge Diener. In hindsight, which is probably the smartest man alive. Now, one thing about this document is they sure talk a lot about Libby German's cell phone and geofencing. Something must have been really bad for Rick Allen in that information, because what I think is the most telling in this document is right here where it says request for sanctions in this section, where the defense wants all data from Libby's phone, including video from all data extractions, be excluded from evidence. Yeah, you heard me right. They want Libby's phone thrown out, not be able to be used in the court. They don't want the jury to know about any information that came from Libby's phone, which is very odd for a person who has nothing to hide. I mean, if he was innocent, the defense should be able to use Libby's phone and the metadata from it and show how Rick Allen was innocent, that he was nowhere near that phone and that he was on his stock ticker and that didn't ping anywhere nearby where Libby's phone was. But yet they want it all thrown out. They also ask in their request for sanctions that they be allowed to bring in evidence about Todd Click and his opinion. They're asking that the state should not be allowed to cross-examine him or rebut anything that he says or anything that's presented by the defense in regards to Todd Click. So to me, this is a sign of weakness for the defense. I mean, why wouldn't you want someone to cross-examine or to refute anything? Why do you only want to tell one side of the story? So also in their motion to compel, they stated that law enforcement had pings of Elvis Field's phone on February 13th, 2017. And well, that is likely why they haven't arrested the mentally handicapped man who lives over 2 hours away. All right. What I find interesting about this document is about Libby's cell phone and all of the focus that they have on Libby's phone. So on page 4 of 11 in this document, you can see all the items that they have under LG's cell phone. One of the most ridiculous things. Number 19 here. Despite being in the state of Indiana's possession for over 5 years when charges were filed against Mr. Allen on October 28, 2022, the extraction and data from LG's, Liberty German's phone, was not provided to Mr. Allen's attorneys until September 8, 2023, 9 months after it was due to the defense. First of all, it wasn't due then because remember they had until November 1st, so that's incorrect. But what gets me is Indiana had it in their possession for over 5 years. Like, who were they supposed to turn it into 5 years ago? All right, moving on. However, even upon receiving the extraction and data from LG's phone, the defense was unable to immediately focus on that important piece of evidence, as the evidence was just one small part of a much larger series of evidence dumps that the state of Indiana chose to turn over to the defense in a roughly 4-week period between September 8, 2023 and October 6, 2023, more than 9 months later than required under the Indiana Rules of Criminal Procedure, which again, it was due before November 1st, but the defense is using their straw man tactic here and disregarding what the actual court ruled. But the interesting part here is evidence that was turned in from September 8th, 2023 and October 6th, 2023. Because remember back in September of 2023, in the 136-page Frank's memo manifesto, they wrote this. Although on September 11th, 2023, the prosecution informed the defense that yet another round of additional evidence is available for pickup. The defense should be picking up the new discovery on September 18th, 2023. Okay, so it says it was ready for them September 11th. The prosecution informed the defense that yet another round of additional evidence is available for pickup, and the defense should be picking up the new discovery on September 18th. So they were complaining about not getting evidence, and then it was ready for over a week, and they still didn't pick it up yet. But more importantly, what they said in that 136-page Frank's memo was, remember these things? They said why Rick was innocent because, one, there's no DNA evidence found that links Richard Allen to the crime scene. They said no data extracted from Rick Allen's phone connects him to the murders, nor does data extracted from Libby's phone. So they made all these statements. And a lot of people still go back to these statements as if they're true today, but they aren't, because these statements were made before they went and picked up a larger series of evidence dumps that the state of Indiana chose to turn over to the defense. So now that they have all this new evidence, those statements that they don't have any cell phone data connecting Rick Allen to the crime scene or any DNA, those statements are no longer valid. Because now, after they get all of this new information, what are the things they start talking about? They start talking about cell phone data and geofencing and geolocation. They even, thanks to David Hennessy, say they need a DNA expert, so they need extra money. So these things weren't brought up in the Frank's memorandum in September, but now they're being brought up after all this new evidence has been brought forth to them. So when people say the state has nothing against Rick Allen, well, just read between the lines here.
What the judge takes away from your argument today?
We have nothing to hide, and, you know, transparency is important in government. It may be weird for defense lawyers, I suppose, to be arguing that we want things unsealed, but that's how confident we are in our client. That's how confident we are that the evidence contained in at least what's written in the probable cause affidavit is nothing for us to worry about.